Hello, landlords. It's Ernie Garcia, landlord attorney. And today we're talking all about possession. When can you definitively take possession back from your tenant after things have gone sideways? We're talking all about that today. Let's get started. So if you own real property and are leasing that property out to a residential tenant and there's been a default, how soon can you step in and reclaim possession? It's not something that's automatic, and it may not exactly be all that intuitive. You may have a document that lays out all sorts of rights, but depending on your state, depending on your jurisdiction, you may have to tap the brakes a little bit on when exactly you can step in and reclaim everything all at once. There's a process usually that you have to go through before you can take possession and not run afoul of state or local law. So we're going to talk about this process in a very general manner. We're not going to talk about specific kinds of notices or specific procedures outlined in state law as they may be where you work or live or own a property. Instead, we're going to talk about things in a general nature. And the first thing that I want to bring up is the issue of default. You're going to have issues of default where you have a written agreement between the parties. If your state allows a purely oral agreement, that's fine, and that can exist. But really what we're talking about are residential leases signed between a landlord and a tenant that have clearly stated rules. And so that lease is going to be your best point of reference when you're talking about the things we're discussing today, particularly if you're discussing some form of default. Now, when it comes to landlords and tenants, the most common default in which a landlord would be entitled to demand possession back would be non-payment of rent, but it's not the only one. You can, and if you've watched other videos of mine on this channel, you can implement a strategy for demanding possession after a certain number of breaches or certain kind of breach. That requirement is probably going to be based on what would logically make sense in your jurisdiction or what is absolutely required by the rules of wherever it is you live in your state or local area. But can you, after the commission of any independent default, simply come in and say, that's it, you got to go and I'm going to help you? Well, generally speaking, the commission of a single default on the lease does not give you the authority to simply go in and start putting your hands on people or their property to usher them off of the premises. Instead, what you're likely going to be required to do is issue some kind of written notice to them demanding that they leave. Well, let's say that you followed your state and local laws and you have in fact given your tenant a line in the sand. Many states have a 3-day notice requirement. So let's say you've given something like that or the equivalent in your state or local jurisdiction. You've given the notice, you've waited out the days, and now you're coming back and they have not left. Can you at that point step in and physically remove people or property? No, still no. You're not allowed just yet to do that, particularly if in your jurisdiction you have to go through the full process or get a very specific permission from the court before you're able to assume full possession. I realize that it is extremely frustrating to deal with a tenant who you've demanded to leave, who has violated the lease multiple times, who has not kept up with their end of the bargain. But you know what isn't frustrating is you giving us a like. If this is something that's helpful for you, please let us know in the comments below. And if you're not yet a subscriber, please consider subscribing. Well, let's say then that you've got a tenant who has committed a default or multiple defaults. You've issued written notice to them, and now you have filed an eviction petition at the court that handles evictions in your area. In the state of Texas, that would be the Justice of the Peace. So you filed your eviction and the matter will proceed to trial. Now that you filed, are you allowed to go onto the property and send everybody out? No, not yet. The fact that you filed has not given you any additional rights yet. The matter is still unresolved, but this is a necessary step in gaining the right to exercise your demand for possession. The fact that you filed means that you will get a chance to present your case at trial. So let's say you've been given a trial date and you head to trial and you present your case to the court. You've shown the court the agreement that you and the tenant have entered into. You've illustrated that the tenant is now in breach of that agreement. You've proven that you gave written notice of that breach, and you've established to the court that you've been damaged either by some debt of unpaid rent or the fact alone that you simply want possession back of the property. You've proven your case from start to finish, and the judge has agreed with you and even written an order saying you are entitled to possession. Now that you're holding that judgment from the eviction court, are you allowed to go into the property and usher people out? Now, you would think that at this point you could, but unfortunately you still cannot. That judgment alone is not enough for you to go and force anyone off the property. And that doesn't make sense at first, except for the fact that the tenant in your jurisdiction likely has an absolute right to file an appeal. And generally speaking, you'll have to wait out that appeal right before you can take the next step. And so because of that, the judgment alone is not enough. It's not enough for you to grab a copy of that judgment and wave it in anybody's face and say, ha ha ha, I won, and there's nothing you can do about it. But the truth is that even after you've won a judgment, the tenant still has a few options, numerous rights that they could exercise that would prevent you from exercising your right to reclaim possession. So you're going to want to wait out the process so that you can do it in a lawful way. The judgment alone isn't enough. So let's say in your case, the tenant has filed an appeal. And now the matter is going to be heard in front of another judge, and you're going to have to wait a little bit longer. Now, this is where you're going to have to dig into what is required in your particular jurisdiction, because your jurisdiction might require certain things of the tenant while they are on appeal. For example, in Texas, a tenant might be required to pay certain funds into the court registry during the pendency of that appeal. Any non-payment of rent could result in your ability to usher the tenants out quicker. Basically, they don't pay, they don't stay. So let's say you live in a jurisdiction where a requirement like this exists. The tenant is required to pay into the court's registry by date X, and date X comes and goes. Can you at that point show up with a bat and a pitchfork and a torch to the property and say, it's time to go? Again, probably not. In Texas anyway, there is a procedure. You have to file something with the court, or you might have to set a hearing with the court in order to get permission from the judge to proceed. In Texas, we call that permission a writ of possession. So let's say you are now on that step. You have petitioned the court for a writ of possession and have been granted a writ of possession from the court. They've signed the writ and have now issued that writ entitling you to possession. Can you take that document to the tenant, wave it in their face and say, that's it, you filed an appeal, but you didn't keep up with your agreement. And so because of that, this document allows me to kick you out? Still probably not. Now, the rules and the way this is carried out is going to vary from jurisdiction to jurisdiction, but essentially in the state of Texas, the writ is not enforced by the individual. It is enforced by the county. Specifically in Texas, generally you're going to find it enforced by either a sheriff or a constable. And the constables will go out in the state of Texas and literally tape the notice on the outside of the main entry door of the rental unit. And that notice is going to say, I will return in X number of days or X number of hours. In Texas, it's a 24-hour notice. But that notice will give warning to the tenants that when the peace officer returns, they will be ushered off the property. This is the final step. And so, can you, once it's posted, show up alone? Well, the notice itself says otherwise, and you'll want to follow even that rule. In the state of Texas, you'll coordinate with the constables and show up on some morning to exercise the writ of possession. And if the tenants are still in possession at that time, by order of the court, here's what happens in the state of Texas. The constables will usher the people out, and then you and probably a crew of people will go in and pull out any remaining personal property of the tenants. Unfortunately for the tenants, many times, unless that property is stored, they've probably lost connection with it, because generally speaking, that property is going to be deemed abandoned by the tenant and will likely be discarded. But it is at that time, once the unit has been emptied out, once the writ of possession has been enforced by the constables, that you can change the locks and assume full possession. Now, that's a long set of requirements, and this presupposes that the tenant has stayed all the way through the end. But what do you do if somewhere in between it appears that the tenant has left? We sometimes refer to that as abandonment. So when can we finally determine that a tenant has abandoned the property? It's complicated, because I have landlords all the time who ask me, Ernie, I stepped onto the property, I gave them a notice to vacate, I filed the eviction, we're set for trial in a week and a half, but it looks like they are gone. Can I take possession now? Well, definitely in the state of Texas, if you step in and you discover that the tenant has 100% vacated the property, you sent them a notice to vacate, and there are no people and there is no personal property left behind, then yes, at that time, you are allowed to step in, change the locks, and assume full possession of the property all over again. There would be no need, unless you are interested in collecting that judgment, there'd be no need to proceed at that time if you were already done with the matter. You could just non-suit the case and the eviction would never stick, or you can follow through, get your final judgment, especially if you're owed unpaid rent. But as far as possession goes, you could at that point, once the tenant has fully vacated, resume possession, change the locks, and then begin to prep the property for a new tenant and a new lease. But what if instead it seems like some of the stuff is out and there's stuff left, but you can't tell if they're in the process of moving out or they've abandoned everything and will never come back? I've had landlords tell me that units have been left fully furnished and that tenants have simply left in the middle of the night, gave no warning, left no message, will no longer respond to phone calls. How do you deal in the situation where they've left most of their stuff or significant amount of stuff, or what? The first place you're going to want to look is your lease. Your lease may have an abandonment clause in it. Read it, follow that, consult local counsel about the rules having to do with abandonment. I'm going to talk to you a little bit about what is common in the state of Texas whenever we have abandonment. So essentially what you want to do is you want to post notice, and your lease may describe a procedure just like this, where you're posting notice for your tenant and saying, it looks to me that you have abandoned the property. I have reviewed the situation after demanding possession, and filing an eviction potentially. But I've reviewed the situation, and in my estimation, it appears that you have abandoned. However, if you have not, please contact me within 48 hours or 72 hours or some reasonable amount of time. Again, your lease may have a specific requirement, but in your notice, you give the tenant a reasonable opportunity to contact you to come and get their things. Otherwise, you'll mention in the notice, if you fail to contact me within this amount of time, I will declare your personal property abandoned and may discard of this property as mentioned in the lease. Now, hopefully you have a procedure like this in your lease so that it makes it very simple to simply carry out. If you have no procedure like this in your lease, then consult an attorney and make sure that in your jurisdiction, this or something like it is a reasonable method of dealing with your tenant's personal property. You certainly don't want to run afoul of state or local rules that require you to hold on to it for a certain number of days before you are allowed to discard it. But if you do have a procedure and your state and local laws do allow for abandonment in this way, leaving this notice, waiting the amount of time, and then clearing out the property might be the best thing for you. You post, you wait, you clear it out, and then you're able to take possession of the property. Now, I tend to recommend to landlords to try to reach out to that tenant in every known way, whether it's in the lease or not. If you've got a personal email, a work email, a phone number, so you could text them, you could call them, you can mail notices to them. Any way that you can get a hold of them, if you have connections on social media, reach out to them and give them every reasonable opportunity to come back and get their stuff. Because what you don't want is for them to come back to you and say, trial was 10 days out. I was still in the process of moving my things when you came in and illegally threw away my stuff. However, if you have contacted them and given them a reasonable amount of time, specifically if you've done it in accordance with the terms of your lease, and your estimation was itself reasonable, that the things that were left behind appear to you to be abandoned, then you've got a strong defense in the event that they ever try to come against you with some silly claim for getting rid of their stuff, even though you followed the abandonment procedure that's laid out in your lease or that is explained in state or local law. You always want to do whatever you need to do in order to protect yourself from any kind of claim like this. But once the unit is abandoned and you have followed all that procedure, go in, clear it out, change the locks, and assume possession. Now, for those of you who are interested in a do-it-yourself path to eviction, maybe you're in a position where you need to institute an eviction, but you're not quite ready to hire an attorney to assist you, or you need some assistance, but you can pretty much figure it out on your own as long as you had a bit of guidance. Well, I'm happy to share with you an eviction course for landlords in the state of Texas who are interested in learning more about the eviction process. I have an eviction course that I've created that takes you from start to finish, all the way from notice to judgment, even through the appeal process. If you go to my website, www.attorneyeg.com/EV, you can take a look at what we've got there and see a description of this course. It's 6 modules that takes you from notice. It has forms that we walk you through. I even instruct you on how to fill out notices, like a notice of termination, a notice of non-renewal, a notice of default, a notice to vacate, all of which line up perfectly with the state of Texas and the requirements for a Texas landlord to evict a tenant in a Texas court. I then guide you through the process of filing, trial, and even appeal. If this is something that you find would be helpful for you to know while you're filing your first, or maybe you've filed 1 or 2 evictions in the past and just want to make sure you're doing everything right because you've got a challenging one in front of you, I strongly encourage you to go to www.attorneyeg.com/EV for our eviction course. Any questions you have, send me a text or an email, and I'll be happy to answer questions about that eviction course for you. That's attorneyeg.com/EV for your eviction course. But landlords, I'm happy to help in any way that we can. And it's important for you to know when you can exercise your rights to the fullest extent. So like the issue of possession or eviction itself, or any of the various topics here on our channel, YouTube seems to think that this video right here is the next best thing for you. I welcome you to check it out along with all the other content here on this channel. I appreciate your support and all the things you do here. And until next time, landlords, happy leasing.